This morning we are going to be talking about, when our fantastic investigative journalists do the work that they do, how can civil society turn that into action, and particularly law enforcement action. In full disclosure, why I'm moderating this panel is I'm one of the law enforcement advisors to this program that we call GAC. And I have been doing that since I retired from the FBI at the end of 2018, so about 3 years now. I was particularly interested in having and doing this particular type of work because I realized when I worked in the FBI that the investigative journalists, you're not everybody you talk to is a source. Sometimes they're victims, right? Victims of corruption, and that you are going into places that I, as a law enforcement officer, could not go into to get evidence. And so making that connection there, but the challenge is, right, we have, particularly in the US and, the EU, we have very strong protections for the work that journalists do. And so that line in terms of what law enforcement does and what journalists does, while it is a sometimes mutually beneficial relationship, there are certain rules that we need and lanes we need to stay in to protect the work that law enforcement does and also to protect the work that journalists do. And so one of the things that that we'll talk about this morning is how do we bridge that, those two lanes so that we can, again, take that work that journalists do and turn it into particularly law enforcement action without harming the journalists themselves, their sources, and not compromising their, or appearing to compromise their integrity, in the reporting that they're doing. And that's where you have a role that civil society can play, and in particularly, and as you'll hear this morning, what the role that Transparency International has played in this particular program. So with that introduction, what we're going to do this morning is I'm going to let each of the panelists introduce themselves and talk about their particular role and what we're actually talking about here when we talk about GAC. That's obviously a very important first step. And then I'll ask a couple of moderator questions, but feel free at the end of each of the panelists' presentations to raise your hand and ask your own questions, because I really would like this to be a discussion. I would ask, though, that you please limit your commentary, because I've been in a few other panels where people have some really great work they want to talk about. But then when you start going on and on about wonderful work that you're doing, you knock out other people from asking questions. So I want to make sure everybody has a chance. If you have a question, or that you limit your commentary and get straight to the question. But otherwise, please, we do want to hear from you all in this, and we don't want it to be sit here where we preach to you all about how this is working without helping you understand how we came to where we are, how it is working, what we can do better, et cetera. So with that, I will turn it over to Drew Sullivan. He's going to start by talking about what we mean by GAC and how this came to all be.
So, obviously TI and OCCRP do not have really good marketing and advertising teams, so we ended up with GAC, which stands for the Global Anti-Corruption Consortium. And really this came about because of, talks between us and TI and OCCRP's concept of, how do you fix corruption? And really our theory of change, if you want to call it that, is that there are really four pillars of anti-corruption work. The first is investigative reporters and civil society organizations that expose the corruption. The second is really the activists who look to systemically destroy what has been learned by this exposure. And then the third is law enforcement, which comes in and arrests people and stops this from happening. And then the fourth pillar is really policy. And the problem has always been traditionally these pillars don't talk to each other. Investigative reporters go out and do their own work. They don't share any of their information except the final story and then go off to another story. And then the activists have to recreate what the investigative reporters did and then do it themselves. And then law enforcement says, I can't use any of this, I got to start all over from scratch again. And then finally you have the policy people who don't know what's going on because all the information is all over the place. And so this didn't seem like a really effective way to deal with this really pernicious problem. And so the idea behind GAC is what of these barriers can we tear down? You know, which of these can we really get around? And so we decided we were going to do something, you know, rather controversial in the news industry. We were going to work with activists, believe it or not. And for this, we were heavily criticized. I was called an unethical bastard. Normally, I was just called a bastard, but, you know, I got the unethical thrown in there. And it really was looked down upon in the news industry, and a number of organizations at conferences like this would openly say this is a terrible idea. And it was incredibly risky, and we realized that. But we work in places that are just different from what they used to be. We work in places that are incredibly corrupt, where really, you know, civil society is kind of on the last vestiges of surviving. In some places it's gone. And so we really have to shake up and try to do things. So we set some rules, and we decided that we were going to communicate with TI, and we were going to tell them what areas we were working on, what kind of topic areas, and to give them an opportunity to get some of the data and to get some of the information ahead of time so that they could really plan things. Because what often happens is, you know, if you do a story, within about 3 weeks, that money and that property and everything has disappeared. It's moved somewhere else. And then it's too late for the activists to really do anything. And we as journalists, we love impact. You know, we don't look for it. That's not our job. Our job is not to decide what happens with the information we put out, but we love it when something happens. And to actually have somebody take up, you know, the cause that we've put out and to actually try to make something happen, you know, seemed like a wonderful idea. And in fact, when we did an assessment recently, we found that stories that were involved in the GAC program were 5 times more impactful than stories that were not. And that's pretty amazing because investigative reporting is in itself incredibly impactful. It's incredibly effective, and to say, how do you become more effective than investigative reporting, you know, is pretty amazing when you can add that extra element of it. The other advantage at TI is they have some wonderful investigative capacity themselves. Many of their organizations are investigative. And there's a blurring of the line between traditional investigative reporting and activism in places like Bellingcat and other organizations like that. So we're in a brave new world. You know, the ethical and the professional standards issues are really difficult. But we've actually found that you know, if you can build that level of trust, if everybody gets comfortable with the type of relationships that you have, and you can you know, handle these really difficult you know, ethical issues that come up in the process, you can do it. You know, and so we've been doing it now for 3 years. We're actually trying to expand to include other news organizations and other activism groups, and to really make this part of the way investigative reporters work. We're still have some, you know, we've broken down some of the barriers. They're back to calling me just the bastard again, you know. So it's not as bad as, you know, they've gotten some of the unethical out of their system. And we think that going forward, more and more news organizations will adopt this approach. And we can't, you know, the other element of this is we can't really work with law enforcement. That's kind of the problem we have there is that we work with organized crime. We talk to organized crime. We have Stefan Dojcinovic here and Paul Radu have probably talked to more organized crime figures than any 2 reporters on earth. You know, we regularly have to go in and talk to them, and if they know we're talking to law enforcement, you know, it's a problem. You know, if they know we're quote-unquote cooperating with law enforcement. So that actually, the way GAC works is we don't, really work with law enforcement, but our partners can, and TI works with law enforcement all the time. So the information eventually gets spread to the widest possible audience, public information that people can use to really do something about it. And so that's why we're believers in it. We've not hit a disaster yet, which I expected, and so we're going to push forward and encourage more news organizations to do this.
Good morning. I'm Adam Födes. I'm a legal advisor in the International Secretariat of Transparency International. And I work closely with colleagues from OCCRP since the beginning of the Global Anti-Corruption Consortium. And how it started on TI side, when the Panama Papers came out, and we said, wow, this is big. This is really serious. So bad that we didn't know anything about it. That it was coming, and the details, and there is a big splash. There's a big scandal, which may be in the news for a week, for a month, for some month, and then it's over. And our thinking was, if we knew it was coming, we could have prepared for it. We could have prepared in different ways, and what we are doing now in the Global Anti-Corruption Consortium. Two kinds of advocacy. One is a policy type of advocacy. There is a story that illustrates, okay, anti-money laundering laws of country X have huge shortcomings, and something should be done about it. And if we know roughly what is coming, so which country, what anti-money laundering topic, because it's also a huge area. We can prepare our policy positions, we can prepare some campaign, and we can really build on the media attention. And that's really impactful. So that's half of our work. And the other half of our work is the legal accountability. In these stories, there are bribe givers, bribe takers, money launderers, all the enabling industry, there are many criminals. And these stories are really solid with amazing evidence. Otherwise, OCCRP would be in deep trouble, which means when there is evidence and there are no other obstacles like statutes of limitations or immunity rules or people who die in between committing the criminal offense and the story is published. So when there are no significant obstacles, then we have a chance to bring a case based on the investigative articles, based on the evidence that the investigative journalists collected. And Transparency International is present in more than 100 countries. Each ground corruption story has at least 4 or 5 jurisdictions. Sometimes it's 15 or 20. So when we read a story and analyze it, then we have to figure out, okay, which jurisdictions are at play, where is a good nexus, what procedures would make sense, do we have a chapter there, is the chapter happy if we worked on this case, do they have a lawyer in-house, or do we need pro bono support, or there's not even possible to have a pro bono support. What specialization we need? Is it an environmental corruption story or something with massive human rights impact? Then who else? Who should we need? What partners? So another NGO specialized in let's say, environmental protection. And we can put together then the legal submissions and make the actual submissions. And that's only the first step. These cases can take long years. So it's important that Transparency International has been around for some years and hopefully will be around for many more. So you need the stamina to follow up on a case for long years. And that's what we are doing in most of these cases. Okay, sometimes the case is over and you can't do anything, it's just dead, and we exhausted all possibilities. But otherwise, like good bulldogs, we just hang on to the case and we pursue for many years.
Okay. Good morning, everyone. My name is Henri Thulliez. I'm a lawyer in Paris, but I'm here as a co-founder and director of an organization called PPLAAF, the Platform to Protect Whistleblowers in Africa. We are not as famous as OCCRP and NTI, so I'll take the liberty to explain to you what we do. PPLAAF was created in 2017 by lawyers, activists, and investigative journalists to create a community of experts to provide services to whistleblowers whose disclosures can have an impact on the general interest of African citizens. Basically, we offer free legal protection to these whistleblowers. Sometimes we offer security, which can lead to relocation of a whistleblower and his or her family because of the dangerous environment he evolves in. And we work and we provide media and investigative assistance to a whistleblower. Basically, when a whistleblower approaches us, we conduct a preliminary investigation to assess the credibility of the whistleblowers and the information he or she has. And we help the whistleblower to develop a strategy depending on what he or she wants to achieve by blowing the whistle. Does he want to go to legal impact? Does he want to have impact to the public opinion? We do a case-by-case strategy, and then we try to implement it. Since 2017, we were one of the receivers of the Gupta leaks in South Africa. We've been supporting the whistleblowers behind the state capture scandal, which led to the creation of the Zondo Commission and the resignation of former President Jacob Zuma. We were also the receiver of the Luanda leaks, which we shared with IACC. And more recently, we did a project that was called Congo Hold Up, where we had helped whistleblowers behind the leak of 3.5 million banking documents from a bank in Kinshasa in the Democratic Republic of Congo, which we shared with 19 media and 5 NGOs. We wanted to bring together activists and activists and media to work together, both in a way to see how we can publish articles, but also because some NGOs can have more resources than media themselves and can spend more time in doing more detailed reports, more forensic investigation reports. But what is important for us is that at the moment we receive a leak or we have a whistleblower and this one wants to get both legal and media impact, we assess the legal potentials of the leaks and the documents that he have. We do it at the early stage, and we are going to try to work hand in hand with journalists, but also with activists to see how the media disclosures could help to feed a pending investigation or could help us to trigger prosecution or litigation somewhere. And it has worked a little bit. I mean, we get a few people sanctioned in the US, including the Gupta brothers and Isabel dos Santos, some of the friends and inner circle of Dan Butler. But for example, we did manage to get investigation triggered following Congo holdup in many countries. I cannot quote all the countries in question, but we have, for example, investigations going on in Belgium against a billionaire who had been the accomplice of former President Joseph Kabila. And we have a pending criminal investigation in France against a corresponding bank, which had helped the local bank in the DRC to access the international banking system. So it's probably one of the first time that a bank may be indicted and prosecuted for being an accomplice of public money laundering. And I think that all of that was possible because we foresee legal actions at the early stage. We didn't wait for the articles to be published to think about the legal actions. We were thinking about the legal actions immediately, working with lawyers, activists, but also with a journalist, because we were acting in a transparent way with them about what we could do. But also, and most importantly, this was possible thanks to whistleblowers. Whistleblowers are the best tool to fight against corruption. They are the best witnesses you can think of. They are real insiders of an opaque network. And they really help to enlighten acts that are meant to remain in the shade in the opaque world. And that's these people that PLAAF wants to help. We want to help whistleblowers for kleptocrats to get scared. We want to help whistleblowers for enablers to understand that any of their employees may one day blow the whistle and come to us. And PLAAF wants to help whistleblowers for the justice system to have access to clear information and evidence that could lead to prosecution and litigation. We basically act as a team of commando. We like to, I'm using the sentence that was used by the founder of PLAAF, French lawyer William Bourdon. He said that we need to act as a commando team, ready to bring support to these watchdogs of the rule of law, but also to help the justice system and to fight against impunity. Thank you.
Thank you. Good morning. My name is Mary Butler, and I don't show up on the advertisement for this panel. It's not to protect my identity. I have business cards if anyone's interested. I am a career prosecutor with the United States Department of Justice. I work in the criminal division, and I work in the money laundering and asset recovery section. I oversee the department's kleptocracy asset recovery initiative. We're different from the fraud section's FCPA unit, which some of you may know about. We're different in the approach of the focus that we try to take, but also we're just different people. There's 30 or so lawyers there. I have about 28 on my team. In full disclosure, Karen and I worked very closely together when she was with the FBI because she oversaw the kleptocracy portfolio, I should say anti-kleptocracy portfolio for the FBI in the International Corruption Unit. I want to talk about how our program can be more successful through the work that you do, but let me first, before anybody's eyes glaze over, keying on my colleagues' statements. In case you don't know, there is something called the Kleptocracy Asset Reward Program. It's on the website of treasury.gov, US treasury.gov. It was created to try to allow for financial rewards for people who provide information that leads to the seizure, confiscation, and actually return of assets linked to kleptocracy. It's in its infancy. We're hoping that Congress will give us more money, but the idea is that those of us who do this work understand that, of course, whistleblowers, eyewitness information, or their ability to connect us to an asset that we couldn't identify is critical for our success. And we know that in doing that, in coming forward in whatever way they need to, they're going to incur security concerns, and that money is often the only way to allow for relocation of themselves and their families, to deal with the fact that they may no longer be able to get jobs. So this obviously, if it incentivizes people, that's great too, we don't mind. But it's in recognition of the real risks that whistleblowers have to take. So I want to get that out there so that all of you hear about it because you have the sources. Everything that I say is going to be focused on the US legal perspective because that's really what I know best. The Kleptocracy Asset Recovery Initiative was created to fulfill the United States commitment under UNCAC and other international commitments. The commitment is to try to recover assets linked to foreign corruption that are in the United States or used the US financial system, and to try to return them for the benefit of the people harmed by the corruption. And it's important that I say for the benefit of the people harmed by the corruption, because it is not our mandate to return recovered funds necessarily to a government, but that there are great challenges in the return process. We are litigating in courts for about $3 billion worth of assets, and of course, a number of individuals' liberty as well. We have returned $1.7 billion in liquidated assets since 2010. 1.2 billion of those have been recovered, or we assisted in recovering them for the benefit of the people of Malaysia. So I don't want to overstate the number of countries we've been able to impact, but we're aggressively trying to do what we can, and the work that journalists do is key to our success. So I'm happy to talk in more detail about how we can use the information that you provide, the limits on how we can actually work together, but it's obviously critical to our success, and there are a whole lot of people working pretty hard, not just to learn about corruption, but to actually take some action.
All right, so kind of with that introduction, let me let me kind of emphasize a couple of points here. We started out talking about GAC, but obviously Henri has his own structure. GAC is just a structure, right? It was a way to bring together this idea of taking what journalists and the work they do and having that greater impact. It's not the only structure out there. Obviously, Henri has his. There are other structures that are out there. And I should also emphasize that GAC just doesn't work with the U.S. So I'm the U.S. Law enforcement advisor, but there are other advisors in other countries where submissions go to that come out of the GAC. The goal of the work that that the way that we work is that when a journalist writes a story, that story gets turned into a submission that goes to a particular country, the country that either we think has the best jurisdiction, the country that they think, perhaps can make the most use of what the reporting is, that's, in particular, where the asset might be that's identified in the story. So, there's considerations after, when TI gets involved, and I'm sure Henri's considerations are the same, is, okay, now we have this, we think there's something here that we can take to, get some sort of, and it doesn't necessarily have to be an asset recovery. It can be sanctions, like Henri talked about. It can be, just using what's in the story to go to policymakers, right? So we may not have an asset, but we've identified something that has happened in the story that the story could be used effectively to advocate to policymakers in countries. So it has not just that one usage, where we're talking about submissions, that's part of it, but it has a range of ways that TI assesses, or I assess, particularly from the US perspective, what we can do to take this information and this reporting and turning it into, something that will get some sort of action from it. But I want to key on the one part that both Mary brought up and Henri brought up, and that is the security of the people who are, contributing to this reporting. And so, Henri, if I could just ask you a question here. When you talk about helping with security, and I don't want you to go into any particular details, obviously, as to how it actually works, but you're not a law enforcement agency, so can you kind of generally describe what possibilities you have in order to help people with their immediate security issues? Because that's one of the things in some of the countries that you all are working in that are obviously a true concern. And a journalist's sources often are protected, but, and their identities are protected, but civil activists, right, don't have the ability to protect their sources generally. So that's why I'm interested in Henri's response to that.
Thank you. Thank you. It depends on it's a case-by-case basis. It depends on the sensitivity of the information that the whistleblower has. It depends on the country in which the whistleblower is. and it depends on the kind of need we can provide. For example, we did help whistleblowers in South Africa. We felt that the justice system was strong enough and independent enough to only support the whistleblowers legally, so to have lawyers and sometimes to have the assistance of certain NGOs and advocacy groups to protect them publicly. But sometimes we help whistleblowers who face death penalty or who would face real physical danger if they would stay in their country. So in these situations, well, it's only by working in a collaborative way, in a horizontal way, that we can find networks of people, meaning civil society groups, diplomats, embassies, authorities, to try to explain the case of a whistleblower to a friendly embassy who would agree to provide a visa for the whistleblower and the whole family, and to have a country that would agree to host the person and to provide asylum. So we don't have a defined strategy because, again, it's a case-by-case basis, but the aim is to find a way out for the whistleblower. Obviously, we are very clear with the whistleblower that relocation is a very difficult process, it's a dangerous process, it's a costly process, and it's very difficult for the whistleblower to get integrated in the country where he or she decides to go. But we didn't find any other way to do it safely than to get them relocated. This also requires a lot of resources to do so. So we only do it in very selected cases when the whistleblower is, again, in a very dangerous situation, but also because the information that she or he has deserved this kind of mobilization on our end. And we do have friendly states who understand the concerns of whistleblowers, and I think this was not possible 5-10 years ago, but it's also because I think that we are in a situation where the future doesn't look good at all. So we have corruption, and now we have climate change, and we need to be proactive if we want to see change. And whistleblowers are really helpful for that, and authorities agree with that now. And I think they are a little bit tired of this impunity. I mean, I will wrap up here. You don't believe, enablers and corruptors and kleptocrats, they are not 1 or 2 steps ahead of us. They are like dozens of steps ahead of us. Let me just give you a quick example. Recently, I was sharing information with a financial unit, a financial investigative unit in a European country. And we were showing how you have a bank in Congo that has been captured by the family of the president, and how within 2 years you have $300 million deposited in cash in the bank, and that are immediately wired internationally in dozens of companies abroad. Like, there's no way any authority could see that if he didn't have access to the whistleblower. And the investigator close to me, he looked at the data. He had been working in this for 25 years, and he looked at me and he said, in 25 years of my professional experience, I've never seen a scheme like that to launder money. This is just to tell you how far we are from what's going on, and how much we need the goodwill of everyone here to collaborate horizontally and to get things done. And I think, again, authorities can help. Thank you.
Mary, would you pick that up a little bit and talk about, Malaysia and how the role that, the journalists played, because they had their own sources that were feeding into their reporting that eventually ended up into our case. So could you kind of talk about how that flow worked a little bit?
Yeah, I will. Let me first give a little background. In the Kleptocracy Initiative, we have available to us criminal prosecution with the possibility of forfeiture, but we also have non-conviction-based forfeiture, where the asset is the defendant. So we have cases, U.S. versus Wolf of Wall Street, U.S. versus one crystal-spangled glove worn by Michael Jackson in the Bad Tour, U.S. versus bank account number. And this is probably the most effective tool we have to fight kleptocracy, because we do not need to have the owner of the property in custody appearing before our court. In the US, we have very limited in absentia prosecution possibilities. So non-conviction-based forfeiture allows us to charge the asset, give notice to everybody we think could have a claim to the property as an owner or for any other reason, and then to litigate with those people about whether they have a legitimate interest in the property. And we have in our experience the situation where nobody files a claim against very valuable assets because they know they can't prevail, or we have the situations where we get many nuisance claims, people who don't have legal standing to fight with us, and we have to pick them off. Sometimes the asset is very small, and we get no claims or we get fights. It's a whole range of experience, which is one reason why it's very difficult to anticipate how long it will be before the assets are actually recovered and available for return. But knowing that, one other piece, and I know this is a sophisticated audience, so you'll get this. In criminal cases, the government's burden is to prove beyond a reasonable doubt the guilt of the defendant. In civil, non-conviction-based forfeiture, which is a judicial proceeding, the government's burden is to prove by a preponderance that there was a crime and that the asset is linked to the crime covered by the statute. Preponderance is like 51%. You are entitled to a jury trial if you want in a civil non-conviction-based forfeiture proceeding, but this tool is, in my view, the only way to make significant impact against kleptocracy from the US perspective because of our in absentia rules established in a long tradition in our law. With regard to the 1MDB embezzlement and bribery scheme, and many of you have probably covered this over the years, as we've laid out in our public filings, it was a scheme where billions were embezzled, and then some of that money was used to pay bribes. About $2 billion of the $4.5 billion moved into the United States or through our correspondent banking system. And the scheme was so audacious that we all should have turned in our badges if we couldn't get to the bottom of this, because this is sort of keying off of, again, what my colleague said. The people who are the easiest, or the assets that are easiest to seize and forfeit, or people to convict, are the people who make mistakes, the people who are audacious but not as smart as, I mean, the perfect crime's probably been committed, but we don't know about it. So in 1MDB, the evidence was everywhere, but the evidence of exactly who was involved and who authorized the embezzlement largely came in the beginning from journalists and bloggers. And the bloggers had great sources, and we didn't know that in the beginning. We were reading it, of course, but it wasn't until we were able to do a parallel independent investigation that we came to understand how good those sources were. And it's not, I think, the case that maybe eventually we might not have figured some of that out, but we wouldn't at the speed with which we were able to in this instance. And I think a significant learning point for us was not just the huge personal risks that some people were taking in order to come forward and get this information out. That was, from your reporting, right, a prosecutor who may have been involved in trying to investigate this, his body washed up on the beach in a barrel. The Prime Minister passed a law that made it an offense punishable by death to cooperate with foreign investigators. The pressure against cooperation was enormous. But people took some amazing risks, and that really accelerated the process for us. And because we were able to come out early, in our perspective early, and lay out in civil non-conviction-based forfeiture complaints the scheme that we had investigated using information that we got from good sources and were tipped off to by bloggers, created debate based on the information that we put in the public sphere that led to regime change in Malaysia. And that's not our object, but sometimes it's a collateral benefit that comes from public discourse in democracies that have the possibility for that kind of debate. So it's a case we're hugely proud of, but that really we were tipped to by bloggers.
So Adam, following up on what Mary said about that regime change that came out of Malaysia, and for those of you who are not aware, what happened was about in 2015, the US filed this first civil forfeiture case, which was over $1 billion. And in that, which Mary referred to, not only did we list all of the assets, the US list all the assets that they were freezing to which they did eventually forfeit, which included, ironically at the time, the Wolf of Wall Street movie, which was eventually forfeited to the US government. So for a while, the US government was receiving royalties from the movie about another FBI case where a guy ripped off Wall Street. So, you can't make this up in real life, right? But there was that also, like Mary said, that started really, there had been some protests in Malaysia before, but there were initially some investigations in Malaysia, but then the prime minister at the time, who now, by the way, is convicted and has been and is sentenced to and is serving jail time, 12 years for his part in the scheme. He cracked down and literally fired all of the people who were working on this, who were good, independent law enforcement. And in fact, for those of you who don't know, at the time that this was going on, IACC was holding its conference in Malaysia. And so initially, the FBI had hoped that we were going to send some people to IACC that potentially might be able to talk to some of the investigators and prosecutors. But as Mary said, they were all removed, and some of them were jailed, and at least one of them was killed. And so what happened then is the U.S. files a civil complaint. This starts the public discourse, and it started mass protests in Malaysia. Over what the U.S. had put out in the public domain, thanks to what the journalist had also been reporting on publicly. And now there's a great book about it if you haven't seen it. But my question to Adam is, so when you're looking at this, we're not looking at just that recovery. There's more to the impact than just the recovery. So can you talk about civil society's role beyond just that submission, in this process?
So I don't know, is it on? Yes, great. So the first step is this submission, and it may seem unnecessary in some countries. In an ideal situation, maybe it's unnecessary, but for example, in my country, I'm coming from Hungary, the deputy of the prosecutor general says, when somebody asks, okay, this is in the media, huge corruption story, have you read it? Yes, we read newspapers. So you receive your newspapers in your office? Yes, we receive newspapers. Why don't you act upon it? That's not official knowledge. Somebody has to file a criminal complaint. Otherwise, we don't act. So there may be other countries with similar attitude, or other authorities, and there you need the NGO. So first step, submission. And submission is really a first step, and in some countries, you don't hear back from the authorities for a long time, or ever. If If you file something in the US, they say, thank you, we received it, and then silence. Same in the UK. If you file a submission in Germany, they say, yes, we received it, and you will receive very official feedback saying we open an investigation or we refuse to open an investigation, and you can challenge it. If there is an NGO there who made the submission, then you can play the whole criminal procedure code. That, okay, refused, can we challenge it? How far can we escalate and see that actually there is an ongoing investigation? Or, for example, in the case, it's one case that belongs to the Azerbaijani laundromat scheme. So the Azerbaijani laundromat was a $3 billion slush fund for reputation laundering and money laundering and for many purposes. And there was a former member of the German parliament of the Bundestag and the then member of the Bundestag, and where we made a criminal complaint and we received the feedback from the prosecutors. They say, we don't open investigation. Unfortunately, we don't think that any crime happened. Goodbye. And we were thinking, okay, what to do? Should we challenge it and still push the prosecutors into action? Or we just say that German law is really bad. And it took for Germany 10 years after signing the UN Convention Against Corruption to ratify it. They said we ratify only when it's perfect, when we have done our homework. We won't ratify before. And we cannot ratify yet because our criminal offense of bribing members of the German parliament is just not yet there, and we are negotiating. It took 10 years. So after filing a criminal complaint and getting the feedback, we won't investigate, so either the law is bad, which is good for us for advocacy, saying, okay, fix your law, or we can go the other route and the law is good, but the prosecutors still disagree with us and we have to pursue that way. There you need an NGO. Journalists won't do it. Journalists don't have this role, challenging or filing even submissions. They expect that people read what they found, they move on to the next story, and NGOs follow up. There's another case. There was an article about the mention of the former autocrat or dictator of the Gambia, Yahya Jammeh. And there was a mention here in Potomac under his wife's name. And we made the submission that, by the way, there is a mention. Dear US authorities, do you know about it? And this resulted in the seizure and actual confiscation of the mansion, and that was so it's being sold now, and that money should return to the Gambia. There's a new government in the Gambia, so the president is out, luckily, and it's not that huge amount of money, $3 million, but still, it's significant, and especially in the Gambia where standard of living is not that very good. There we work together with our local contact group, Gambia Participates, and working on so they prepare a plan with victims organization on how to return the asset in a way that it really reaches the victims. So how will the victims in the Gambia, who suffered a lot during this dictatorship, what's the best way that they will benefit in the end? There again, our role is talking with our local partners, talking with law enforcement agencies, bringing in the international standards like the GFAR principles on asset recovery or asset return. So each case is in various phases. Some are at the very beginning, some are at the end, and NGOs or Transparency International has a role in each phase.
So, Drew, one last question to you before I open up to the audience. You know, the generation, this, of course, is the work that your great journalists are doing. Generally, do they have buy-in to this program, or is this something you have to market to them, or are they strong supporters, or do they kind of leave that to you and Paul and in this coordination? And they say, let me just do my work. How do they view and feel about the work that happens here?
So honestly, I mean, at first, some of them were pretty skeptical about it. Some of them were, I would say, negative about it. But as time has gone on, and they see how it actually works, and they see, that they're not being put in a position to be an activist. They have no idea what TI is doing in most of the cases in terms of the actual activism or the filings. And I think they've grown accustomed to this way of working. And actually, they'll do a lot of work with, TI's investigative capacity and other NGOs that do investigative work themselves. As I said, the lines have been blurring. So, but I think when it fundamentally comes down to it, journalists understand, and you're all a pretty savvy audience on the issue of corruption, I think. But the more you report and the more you look at the world, you realize it's far, far worse than you think it is. And this is the depressing thing. Let's just pretend you're a organized crime figure, and you've got $3 or $4 billion from drug trafficking. You can go, first of all, you have your pick of bankers. You have your own personal bankers in about 10 different banks, and they will do anything you say, and they will serve you like you've never been served before. No hold, waiting for the banker to get on the line. You will have 20 to 30 lawyers who cover every single aspect of your life, the smartest lawyers money can buy, and they will tell you where to put things, how to register, where to go, how to register your businesses so that they're all hidden behind, offshore trusts and things that will never be broken by any government investigator or journalist. You will have lobbyists like Paul Manafort and Roger Stone, who will get you into the highest political figures and know exactly when to give the $5 million to the super PAC fund to support them so that you have instant access to anybody in any government that you need. You will be investing, you will have all your money in a blue blood, American, hedge fund, who will give you the best investments and give you special treatment and incredibly low rates. So your money is multiplying. But at the same time, you will be an angel criminal investor where you will be investing in drug trafficking in other parts of the world, and you will give them advisors and you will give them money to support them, and you'll take 30% of their profits per year without any risk to yourself because you're completely disconnected to it. You will have golden visas from about 5 different countries. You'll have diplomatic passports, from becoming the honorary consul in some country, so that you can basically leave any country if you do get in trouble. You'll still drive a stolen car because you're not one of the sheep. You're not one of the people who follow the laws. That's for the sheep. If you talk to organized crime people, they have a term for you. It's called victim. That's how they refer to you, as the victims. And you'll never participate in any of that, but you will use all their systems and you'll benefit from all of it. And you'll pretty much be unstoppable if you're smart enough and you do it the right way. And you will eventually be buying influence and getting into controlling, political parties, and you will team with libertarian billionaires, other organized crime figures, and rogue states to undermine countries that you don't like. And your goal no longer is becoming rich doing drugs. Your goal is state capture. And once you own your own state, you make all the rules. And that's what really people are fighting for right now, including in the United States. It's about state capture. Audacious is the word that Mary used, and that's really what's going on now. And unfortunately, it's not really being uncovered because it is so sophisticated and things are hidden so well with cryptocurrency and offshore banking and all these different things. We're not catching most of the worst offenders of this. And if you see governments doing bizarre things or political people doing bizarre things, it's often because to go into politics now and to go into some of these businesses, you almost have to be corrupt. Everybody else in the industry is corrupt. And you just join them, and it's getting worse and it's getting worse. And, you know, so you think of the capitalism in the West as being some separate system, but it's really been co-opted a lot by profoundly undemocratic money. And this money is seeking to make all of our countries more plutocratic. And I know this sounds cynical and paranoid. I just think it's experienced. You know, that's our experience from looking at how these people think, how they do things, and how they're thinking about the world. And so everything that we can do as journalists, we think we have to try to do.
Excellent. Thank you, Duke. So with that, I think there are probably a number of questions. We've put a mic right here. If you want to come and stand up at the mic, please identify yourself and your organization before you ask your question. So please feel free to use the mic right here in the center. Please come on up.
Aydar Gyubayev, Transparency International, Kazakhstan. Well, first of all, I wanted to reply to Drew, maybe even disagree a little bit. Articles that expose kleptocrats, they have objective value by themselves because they expose a naked king. And that by itself is a real melody of justice. After which the reputation is not absolute. Not everyone wants to shake hands with the kleptocratic leaders after these articles, and that's maybe the whole point, or at least a very substantial one. My question goes to Mary. You said that you had litigation for $3 billion, and then 1.7 was returned, and 1.2 actually was moved to Malaysia. I was wondering why there is a difference, and what are the risks, what are the challenges for the money that would be frozen, that would be identified and received by Justice Department in the US, but they wouldn't be returned to the country of origin. Thank you.
So the $3 billion represents the purchase value of assets that we're litigating. So we don't have legal title to that property yet. That's the goal of confiscation, is we take title, the government takes title to the property awarded by the court. The difference between the 1.7, which we have recovered, and the 1.2, which we have returned and assisted in returning, is the amount we're negotiating to return. So under GFAR principles, and also just common sense, we don't return money without assurances of transparency and accountability, because we want to be able to make the point that the money was taken in violation of the rule of law, and it was returned through the rule of law, and that it isn't likely to be stolen again or misappropriated again. So there's a lag time in the liquidation of assets that we have title to. There's a lag time in negotiating and entering into these final resolutions. A good example is the Gambia. And this is not in defense of why it took so long for us to actually confiscate that house. We read your stories. We know that there are kleptocrats who own houses in Potomac, Maryland. We know that. The Gambia was one we knew about for years. Our problem is we have to link the asset to a specific crime covered by our statute. And the evidence of the crimes was in the Gambia. Who paid bribes? What government funds were embezzled? And it wasn't until the Truth and Reconciliation Commission conducted its hearings and made its findings, that we had an opening to see where this money that bought the Potomac House came from. And so it took us a long time to be able to articulate to a court the basis to believe that this asset was purchased with dirty money. And then, of course, we have to get the final confiscation order, then we have to liquidate. And the house is for sale now. The discussions about how to return the money with the government and in part with civil society have already begun. And so we're in that process, but the Gambia is an example of where that delta is.
Next question, please.
Thank you very much. My name is Ernest Mpararo. I'm coming from DRC. I'm working with an anti-corruption organization in Kinshasa. First, thank you very much for our colleague from PPLAAF. I think I follow up the cases of BGFI Bank, and I can inform you now that the BGFI Bank paid $50 million to the government. I think this is the effort PPLAAF did in order to arrive to this solution. But my question is from the Minister, the Attorney General. When they find someone or a company, the victim doesn't being compensated. We have a case of Glencore, who has been fined here in the US. They paid $1 billion, but in different African countries, they didn't compensate us. So what can we do to have compensation? What can we do? The second question is for our colleague from PPLAAF. Yeah, I know that on national level, it's very difficult to protect whistleblower. Myself, I can assure that I started this work for now 20 years. And during Kabila regime, I sent a lot of cases to the court, but because of judiciary system was not very independent, nothing was being done. But when we got regime change, when the new president came, different cases was being activated, and we have today some people who are in jail. But what we see, it's when the regime change, the new authorities start to have some corruption practice. And the judiciary system where they are not independent, no one will ask them to be accountable. This is the things we have, but today we are working to push, to advocate in order to have a justice which can investigate everyone. So PPLAAF can help us to have some capacity building inside the countries, because now African leaders, they didn't send money here in Europe, because they know that Europe, the rule of law is very, very, very strong. They are sending money in China, in Qatar, in Dubai, or in different countries, African countries. So it's few leaders who are sending money now here in US or in Europe. So on this issue, on this strategic issues, we think that in 10 years future, all politicians, African politicians, will not have assets here in Europe. So they will have assets in Africa or in Asia. So what can we do in this situation? This is my question.
Mary, do you want to start?
So first of all, you gave me a huge promotion. I'm far from the Attorney General. I just met him yesterday. And actually, that's a beauty of our system, that the Attorney Generals come and go, and the career staff, for the most part, continues to do their work, administration in and out. I don't know if I can address all of your issues, but let me just make one point. Keying off the Glencore case that you just mentioned. So Glencore, International Commodities Trading Company, the department announced that it entered into a guilty plea agreement under which the Swiss parent pled guilty to FCPA violations in connection with bribe payments in multiple countries. And then separately, it entered into another entity of Glencore pled guilty for its role in commodities market manipulation in a separate court. And there's news releases on the details of these agreements. It hasn't been sentenced yet. At the sentencing, there'll be the possibility for victims to seek restitution. Under our law, restitution is actually a very limited possibility for compensation, because under our law, a victim has to be able to show a direct pecuniary loss resulting from the conduct. And it's often hard to value or monetize. Well, what did a bribe cost each individual citizen? So and also it's hard for countries to have standing in the restitution proceeding because they often participated in the misconduct. And so that is a legal prohibition for restitution. Where the justice can come in is on the forfeiture, because the limitations are not the same as in restitution. And I would just note that as maybe a collateral consequence of the guilty plea, I see in the newspaper that Glencore says that it has compensated the government of DRC $187 million for its bribery conduct there. So it does seem like there's a collateral positive consequence of the guilty plea. And I guess the challenge will be for people like yourselves to ensure that the DRC government uses that money in a transparent and accountable way to address maybe the vulnerability that led to the corruption. I'm sure that's only a slice of what you are concerned about, but maybe I'll let my colleagues weigh in.
Thank you. You raise a difficult situation is how do you try to do legal accountability in local countries that are damaged by corruption? In some countries we can do it, and we are trying to do it. It's the case in South Africa. We are also preparing other actions in other African states. But regarding the Democratic Republic of Congo, I have to admit that it's quite difficult. For example, PLAAF has been targeted by 2 criminal complaints in the DRC, which we are fighting back. Basically, the chairman of PLAAF, but also the chairman of Global Witness could be sentenced to death, so we are trying to avoid that to happen. And the 2 whistleblowers who gave us information on how mining magnate Dan Gedler had potentially tried to bypass US sanctions, got sentenced to death in a fraudulent trial in the DRC. Fortunately, they were already living in absentia. They were already living in France, so they got sentenced in absentia. But it's just to say, since this happened, there have been a lot of concerns raised by embassies, but so far we haven't been able to get this death penalty cancelled, so you do still get convicted for death penalty in the DRC when you reveal corruption action. So I can only stand here with you about the issues and the difficulty we can have to fight corruption in a country like the Democratic Republic of Congo. And I mean, just so you know, we are not being prosecuted only in the DRC because of what we did in Congo. We also face 9 defamation suits in France, but we are confident we're going to win this. How can you, so going in the DRC is difficult. Just so you know, there is an agency fighting corruption in the DRC that never approached us to have access to our data, although we are available to collaborate. I think you understood that. In general, maybe not this case with the DRC, but in general, we are happy to collaborate. One way, indeed, if money leaves DRC and goes to Dubai or goes to China, we're not going to be able to make many cases, legal cases, but that's where we can actually think about doing cases against corresponding banks. So if you have money in USD or money in euros leaving DRC to go to Dubai, it has to go through a corresponding bank. Usually these banks are in Europe or in the United States. And that's what we are trying to do here, is we are trying to set a precedent whereby a corresponding bank could be found guilty of being an accomplice of public money laundering. This is something that should be replicated. We know that in our case, we have corresponding bank in the US. I think it would be interesting for the US authorities to see how they could go after these banks. And we also have corresponding banks doing nesting, where you have a corresponding bank using another corresponding bank using another corresponding bank. So you have a collection of indirect corresponding banks who will always say that they are not responsible for what's going on, but they are, because they have compliance departments. And these compliance departments clearly know that when you have $15 million leaving the central bank of Congo, going to a company that belongs to Kabila, they know that something is wrong, but yet the transfer goes through. And that's a big issue, so that's what we are trying to do. We will never be able to do a case in China nor in Dubai, but we can try to go after the corresponding banks.
And while the next question, please, come up is being asked, one of the things I would say for those of you who are from Africa is, the African Union has not ratified the Anti-Corruption Convention in Africa. And as an advocacy perspective, you might consider that, because while all of the African countries, as far as I know, have ratified UNCAC, and UNCAC has a mechanism to, review countries' compliance with UNCAC. That's a lot. It is generally often years before a country is reviewed, multiple times in its compliance. But if you have your smaller regional compliance network, that might be a good way to be more proactive in addressing issues of, money laundering and money from corruption going into other African countries. So just that plug from work that I do teaching about basic anti-corruption on what can possibly be done about laundering corruption proceeds into other African countries. So please, next question.
Thank you. My name is Sanjay Modi. I'm an attorney based in New York. My question's for Mary. So in the US, there are a number of statutory authorities that provide for whistleblower awards, and they generally require violations of, the specific statute, whether it might be violations of the Bank Secrecy Act, or violations of IRS statutes, or violations of SEC regulations. At the same time, as you mentioned in response to the previous question, victims might be able to receive awards based upon some theory of restitution, and you mentioned forfeiture as well. I guess I'm just curious, though, as far as I'm aware, there's no general money laundering whistleblower statute. And if that's accurate, what are the prospects of a general money laundering whistleblower statute, and would that actually have an impact on the work of that you do? Thank you.
So there is the Kleptocracy Asset Recovery Reward Program run by the Treasury Department in consultation with DOJ and U.S. law enforcement. And it is intended to provide financial rewards to people with information that lead to the seizure, forfeiture, or return of assets linked to foreign corruption. And most of our cases involving foreign corruption are based on money laundering. So it's laundering of the proceeds of the corruption, laundering of bribe money into the United States through correspondent banks, or the promotion of a money laundering scheme, because the movement of money to pay bribes moves through the U.S. financial system. So you are right that there had been a vacuum for this niche of whistleblower, because there was the SEC program, there was now there's the BSA whistleblower program, but this Kleptocracy Asset Reward Program is intended to fill that gap, and we hope that Congress will expand the amount of money in that fund. I don't say that we, the department, I say because I don't speak for the department on this point, but I think everybody who can see the benefit of whistleblower programs would see the benefit of expansion of that program.
One comment on this, you know, Karen has mentioned in the past that when she was at the kleptocracy branch, more than 50% of her stories originated with journalists and journalism stories. And yet, journalism and activists are the one people that don't ever get compensated. OCCRP has been responsible for about $9.6 billion, which is a 50,000% return on the investment in OCCRP, money that has gone into governments around the world. And yet under US law, we're strictly not allowed to get any money back. And so we've advocated that some of the proceeds that have been seized or fines that have been levied against organizations be sent back. You know, we could survive on the interest of the interest for the money that we've helped governments get back. And yet, you know, we don't have enough journalists and we don't have enough resources. So just something to throw out there.
Yes, please, next question.
Hi, okay, good morning all. My name is Omar. I'm from Ivory Coast. I'm the director of Ivory Coast. I'm the research director of Ivory Coast Agency, Anti-Corruption Agency. I'm glad to be here today, and this panel is very important for us. Ivory Coast has ratified the Ankara Convention, the United African Convention, and we have a national law in terms of anti-corruption law, money laundering laws. But the truth is we have a problem of capacity. We have a problem of capacity. The civil society is weak. The whistleblowers, we got a law, national law on whistleblowers protection, but still people are scared to uncover a corruption act. And most of the agencies who work on, who are supposed to fight against corruption are the government agencies. So as a government agency, most of us are civil servants, and I do believe that the fight against corruption can be properly done by the civil society and by the investigation journalists. When you take Ivory Coast, we don't have more than 2 or 3 great journalists, investigating journalists. So what I want to do here is to advocacy for international organizations here to look up to countries like Ivory Coast, where when you go now, there is peace and the country is really booming. But when a country is booming, has the economic boom, there is corruption, there's money laundering. When you go to Ivory Coast today, people are building 5-storage, 6-storage, 10-storage building in 6 months. You don't know where the money is coming from. You don't know where the money is coming from. The capital is changing. You don't know what it's about, but we need help to strengthen our civil society and to strengthen investigating journalists. That's the advocacy I want to do today. Thank you.
Thank you. Next person, please.
Good morning. Thank you for this really interesting session. My name is Lyudmila Stashunайте. I represent one of Uzbekistan's biggest civil society organizations. And in my country, whistleblowing is, there is a social norm that whistleblowing is accused by the society. And maybe you could suggest some really effective tools we can use to change people's minds towards the advantages of whistleblowing. Thank you.
Henri, why don't you? You knew I was going to ask you.
So you want tips on how to get your country to accept whistleblowers, right?
I didn't say that there is certainly much about legislation and protection of whistleblowers, but just for the civil society, what we can do in this regard.
I think you need to show them what whistleblowers have helped to collect in other countries and how they've helped to get great stories out with OCCRP or other media, and how thanks to whistleblowers you can have litigation and money being forfeited and recovered in other countries. There are a lot of examples of things that were made possible by whistleblowers, and I think you need to show that. I mean, 15 years ago in France, people didn't want to hear about whistleblowers because for them it was like I'm trying to find the word in English, but informants, people who are giving information to the police in order to bring damages to the neighbor or the friend or a snitch. Thank you. Even the current Minister of Justice in France used to call whistleblowers snitches. And now France just adopted one of the best laws to protect whistleblowers in the world. So it's time, time comes by and you need to provide very concrete examples on how whistleblowers can help. So that's what I can think about, yeah.
I would add a bit to this. Whistleblowers are not only in the field of anti-corruption, maybe environmental protection, human rights, etc. Whistleblowers often can prevent major disasters, but telling in time, please fix this and that, so it can save lives. And that can really give very good reputation to whistleblowers. So you may not start in the anti-corruption field to strengthen the protection of whistleblowers and recognition of all the risks they take and all that they suffer because of blowing the whistle.
Yes, that's absolutely a good point. Whistleblowers don't just help us bring cases in corruption. I mean, they can save lives, by, making the government and the public aware of dangerous situations to citizens' health. Next question, please.
Good morning. I'm Roland Pop from Transparency International EU. I have a question to Mary. If you could tell us a bit more about the asset management issues, what you have maybe, let's say, from the day of seizing an asset until the liquidation and how it goes for you. Thank you.
So in the United States, we're pretty lucky because the way our asset management funds are supported, we have actually some operating capital. So we have the ability to take on some of the expenses of maintaining the value of property while it's seized and before it's confiscated. This isn't common around the world, but it is something that we're trying to talk about and explain. Also, our law gives us the ability to conduct what we call interlocutory sales. And that means that we can go to the court and say, this property is seized, but the owner still has a responsibility to maintain the property, pay the taxes, cut the grass, maintain the engines if it's a jet or a boat, and they're not doing it. And our courts don't like to force interlocutory sales the first time we ask, in our experience, but eventually, and sometimes through persistence, as we demonstrate that the property is deteriorated, our courts will order an interlocutory sale, and in that case, we just fight about the money. And this is really important power to preserve the value of assets for later distribution. There are other countries like Ukraine where their legislation says they must liquidate if it's a perishable asset or a complex asset from the time they take possession of the property in a seizure phase. That's more aggressive than the U.S. law, but this ability to do interlocutory sales is key to maintain value.
Next question, please.
Hi, good morning. I'm Siri Nelson. I'm the Executive Director at National Whistleblower Center. I'm really happy about this panel and grateful for the question about U.S. laws. For the money laundering whistleblower program, I also wanted to bring up the FinCEN whistleblower program, which is woefully underutilized, but actually yesterday in the Senate, it was passed by unanimous support to have some better incentives, which will hopefully motivate more people to report to FinCEN about money laundering. And NWC has been a big supporter of that, will continue to be. So hopefully the House also takes action and becomes law. The talk that we're having today really, and also the documentary that I watched last night here about the killing of a journalist, really brought to mind the reality that there is so much evidence readily available that if international law enforcement efforts were interested in actually using that evidence, we would see massive enforcement success and less people getting killed by mafia and criminals. So my question to you all is, how do you engage in legislative advocacy and just social advocacy to help people understand that we have to find mechanisms to take this information seriously, that it's worth the fight and the compromises, and it's worth giving people credit and not taking it all for your own in order to protect the public, and motivating whistleblowers. This question about changing stereotypes about whistleblowers is critical to seeing the mass change that we need in order to really let organized criminals know that they are on the losing side of this fight. Thank you.
Adam, do you want to address the advocacy piece of it?
I'm not sure if I understood well that it's only the cases that whistleblowers bring.
I think, no, I think it's that the potential of all evidence that's out there related to not just what whistleblowers bring, but other sources of information can bring to advocate to governments to have increased and enhanced enforcement. But it starts with the passage of, in some countries, better laws.
Partly, yeah, exactly. Having better laws is part of that, but we always say, okay, these are the laws we have, these are the jurisdictions at play, and bring cases everywhere. It's all right to okay, it may sound harsh, but to play on that authorities may compete with each other, or countries may compete with each other. So I think it's totally fine, and we do it. We make submissions in the same case, in various jurisdictions, or in the same case, to various authorities. One case can be a case for a regulatory authority. At the same time, it can be a case for a criminal justice authority. All these authorities have significant supervision. So there's the parliament, there can be special commissioners, there is the media who is interested not only investigating the case, but seeing what's going on, what the authorities are doing or not doing. And if in a country there's a good anti-corruption NGO, then there's a role of the anti-corruption NGO to use all opportunities to bring or initiate all the procedures possible, follow up, and put pressure on the authorities as long as needed. Even in rule of law countries, that happens often, that an authority is not very keen on working on a case because it's very complicated, resource intensive, requires mutual legal assistance with counterparts who are not very happy to cooperate with anyone. There can be issues, lack of trust, etc. So it's the role of the NGOs to use all opportunities.
Mary?
If I could just add that there's something called the International Anti-Corruption Coordination Center that sits within the NCA in the UK, but it has members from many countries, and then it has observers from many countries. And FBI and HSI and IRS from the United States support and have representatives in this center. And this is intended to do the kind of thing that you are mentioning, which is to make sure that allegations of specific information get transmitted to the hands of the people who actually have the asset or who actually have more evidence. It's intended to try to actually act on this concern that there's a lot known out there that isn't being acted on. So I commend you to start targeting the International Anti-Corruption Center. Karen knows exactly how to find them. And I would also say that, you know, from where I sit, many times information comes to us about the existence of an asset owned by somebody who, according to their financial disclosure reports or other information about their legitimate assets, should never have an asset this valuable. But my law says I have to connect that to a specific crime. And so I need to know who bribed them, what account they stole the money from. And so it's that specific need that is frustrating to you and to me. But that is where all of you can help in the fight, is identifying the people who know and bringing them, encouraging them to trust us and come forward, or in developing it and telling us about it, so that we can try to make either a very strong circumstantial case or a direct case.
Yeah, and just a very quick comment, whistleblowing is evidence that the system has failed. It's evidence that there isn't the transparency, there's not the systems in place, there's not the rule of law and accountability. And so I think we need to also be pushing back, looking at how our systems work, and try to create that transparency and try to create those systems so that we don't need whistleblowers. They're a release valve, they're a pressure release. But really, I think we're not working hard enough to prevent them from having to put their lives on the line, and they're ruining themselves because of the having to do that.
And so last question, on please.
Thanks, Karen. My name is Andrieke Visser. I have experience in all three categories sitting on the panel. I used to work at the Netherlands financial regulator. Then I was an investigative journalist. Well, I still am. You never stop being a journalist. And now I also work as a policy advisor to the Sentry. And I have a very practical question. How do you deal with when professional standards clash, and especially for Andrew? Because what happens if you have the same source, and as a media organization, you don't pay them or you don't help them get relocated, but you work with civil society, and maybe they do work with law enforcement or they do help with visas, and then there's law enforcement that might pay them. So how do you have a very practical collaboration without it impacting your professional standards and maybe even tainting your work? And I don't mean it as an ideological we should or we should not, because I think we should collaborate, but how do you do it practically?
So that's a case-by-case basis. Every single ethical dilemma or professional standards question really comes down to the, a lot of the details of the case. But, what we often do is we just, the increased collaboration allow us to pass people over the wall to civil society organizations who can help them and do kind of the things that we can't do. So if we have a whistleblower, we treat them as we do other whistleblowers, but at a certain point when it's too complex or when we can't help them, we can't, give them money to relocate or other things like that, then we connect them, across the wall to the other groups. We often have people who come to us and they really should be approaching law enforcement. And what we try to do is just talk it out with them to make sure they understand what they're doing. We protect the sources, and we try to get it to the point where, what we're doing is ethical and mitigates harm, and then at that point say, you really should talk to law enforcement at this point, because that's what is going to be in your best interest. So we try to, do no harm is our first rule in investigative reporting.
Adam, we're a little over time, so one final word.
Just adding to this, each case that the whistleblower brings has two angles. One is the wrongdoing, and somebody should investigate and prosecute or take action on the wrongdoing. The other part is protecting the actual whistleblower. Transparency International doesn't have that work. We, at policy level, yes, but at practical level to give assistance to the whistleblowers, but we can do a lot to bring the case, to address the wrongdoing. We have some funds to pay legal fees or to pay a plane ticket for the whistleblower to fly to country X where the authorities are willing to act on the report.
So with that last comment, I want to thank you all for coming today. I think what we have learned is that it is possible for, in this world that we're working in, for, journalists, and civil activists and law enforcement to bring their combined resources to the table to address, the serious issues of corruption we're facing in many parts of the world. I want to thank all of my panelists today for coming here. They will be available afterwards for questions, and I look forward to seeing the rest of you around the IACC. Thank you for coming this morning.